Good morning. This is Heidi Meyers, immigration attorney, and today we are going to talk about a policy change by USCIS that will make it easier for certain people with unlawful presence to be able to adjust to permanent residency in the United States. Now, there are three bars dealing with unlawful presence in the immigration law. One is the 3-year bar. So if you accumulate more than 180 days of unlawful presence, but less than 1 year, and you depart, there is a 3-year bar to admission. If you accumulate 1 year or more of unlawful presence in the United States, and then you depart, there is a 10-year bar to admission. So in the past, USCIS has interpreted this to mean that the entire period of the bar would have to be served outside the United States. So let me give you an example. Suppose Mrs. B comes here to the United States with a B visa, and she overstays for several years, and then she departs, triggering the 10-year unlawful presence bar, and she comes back with a B visa. Now, USCIS in the past has interpreted this to mean that because she did not serve the full 10 years outside the United States, that she would not be eligible for adjustment to permanent residency. She would have to get a waiver, unlawful presence waiver, depart, consular process, and come back. Now, this was a big problem for people who did not have qualifying relatives for the unlawful presence bar. So to get a waiver for the unlawful presence bar, you need a U.S. citizen or permanent resident, spouse, or parent. So U.S. citizen children did not count, or any other sort of relationship did not count as qualifying relatives for the unlawful presence bar. So folks here in the United States who had departed and come back and had triggered the unlawful presence bar were unable to adjust to permanent residency within the United States. They would have to go abroad, either go abroad and serve the full 10 years or 3 years if it was more than 180 days or less than 1 year, and then apply for admission and come back. So this is a big help to certain people who accumulated unlawful presence, departed, returned legally, and then so suppose, let's take our example, Mrs. B. So she departs the United States and she comes back on another, with her B visa again. She's inspected and admitted. And then she's just here in the United States for 10 years. And then her U.S. citizen son is older than 21. He's all grown up and he decides to sponsor his mother. So under the new policy, because she was able to serve her 10 years bar in the United States, she is now able to adjust to permanent residency, whereas in the past, she would, if she were not married to a U.S. citizen, or she did not have a U.S. citizen or permanent resident, and she didn't have a U.S. citizen or permanent resident parent, she would be stuck because she could not adjust in the United States, and then she would also not be eligible for the unlawful presence waiver if she should try to consular process abroad because she did not have one of those qualifying relatives. So for people in that situation, this will be really helpful. This will also be helpful for example, for people who've traveled and triggered the unlawful presence bar and are eligible for, generally, you'd have to come back legally. You couldn't sneak back across the border. This is not going to help you because then you're going to have a problem with the permanent bar. Anyway, so it would also, so it's going to help people who do not have qualifying relatives for purposes of the unlawful presence bar. So it's going to help those who do not have U.S. citizen or permanent resident, spouse, or parent. Or for example, someone who's trying to adjust based on a perm labor certification, they don't have any family members here, or someone who has U.S. citizen children, but they don't have any spouse or parent who's a U.S. citizen or permanent resident. Now, you must be careful, because this does not mean that you can depart and illegally sneak across the border and then get your adjustment. That's not going to work, okay? And in fact, by doing that, most likely you will have triggered the permanent bar. So if you accumulate 1 year or more of unlawful presence in the United States and you depart and you re-enter without being inspected and admitted or paroled by a U.S. immigration officer, you have just triggered the permanent bar. So this does not mean that if you've departed, you can come back illegally and then get your green card. No, it does not mean that. All right, so, and then also, we're only talking about unlawful presence. If you have other inadmissibility issues, those have to be dealt with separately. For example, fraud or some other inadmissibility issue, for that you would have to deal with that separately. So this is only regarding unlawful presence under the 3 and 10 year bars. So for a certain group of people, this is a very good news. All right, thank you very much. This is Heidi Meyers, immigration attorney. You can see our contact information in the notes below. And don't forget to like this video and subscribe to our channel. Thank you and have a good day. Bye-bye.